रेडी। ट्रांसक्रिप्शन नंबर जुडिशियल 800 कितना वर्ड है? 860 वर्ड है। विजुअल कंप्यूटर इंस्टीट्यूट सलापुर पटना बाई एम डी सदा। मोबाइल नंबर 9507 रेडी। 110 से 20, ठीक ना? स्टार्ट। A challenge in these appeals is to the judgment rendered by a learned single judge of Bombay High Court in writ petition number 25,000 of 2004. The writ petition filed by the appellants was dismissed by learned single judge while holding that the trial court was right in its view that there was no scope for granting extension of time beyond the period of 90 days to file the written statement. Factual background needs to be noted in brief. Para. In a suit for partition, separate possession and perpetual injunction filed by respondent number 1, the appellants were arrayed as defendant numbers 15 and 1. They sought time to file the written statement and the trial court granted time till 17th November 2003. On that date, another application was filed for extension of time to file the written statement. Time was allowed till 19th February 2004. As it was holiday on that day, the written statement was filed only on 20th February 2004. Trial court refused to accept the written statement on the ground that the written statement was filed beyond the period of 90 days. The appellants filed this writ petition before the Bombay High Court. By the impugned order, the High Court dismissed the writ petitions. The logic as appears from the orders passed by the trial court and the High Court was clearly untenable. Learned counsel appearing for the respondent supported the order passed by the trial court and the High Court. Para. Order 7, Rule 1, after the amendment, casts an obligation on the defendants to file the written statement within 30 days from the date of service of summons on him and within the extended time falling within 19 days. The provision does not deal with the power of the court and also does not specifically take away the power of the court to take the written statement on record, though filed beyond the time as provided for. Substituted Order 7, Rule 1 intends to curb the mischievous of unscrupulous defendants adopting dilatory tactics, delaying the disposal of cases, causing inconvenience to the plaintiffs and petitioners approaching the court for quick relief, and also to the serious inconvenience of the court faced with frequent prayers for adjournments. The object is to expedite the hearing and not to scuttle the same, while justice buried. Anxiety of Parliament is to secure an expeditious disposal of civil suits and proceedings without the fairness of trial and principles of natural justice. Para. The point for consideration is whether the provision provide for maximum period of 90 days is mandatory and the court is altogether powerless to extend the time even in an exceptionally hard case. It also to be noted that though the power of the court under the proviso appended to Rule 1 of Order 7 is circumscribed by the words shall not be later than 90 days, but the consequences following from non-extension of time are not specifically provided, though they may be read by necessary implication. Merely because a provision of law is couched in a negative language implying mandatory character, the same is not without exceptions. The courts, when called upon interrupt the nature of the provision may keeping in view the entire context in which the provision came to be enacted hold the same to be directory though worded in the negative form. Para. The mandatory or directory nature of Order 7 Rule 1 shall have to be determined by having regard to the object sought to be achieved by the amendment. It is thus necessary to find out the intention of the legislature, the consequences which may follow, and whether the same were intended by the legislature have also to be kept in view. Para. In Saddam Sir and Municipal Corporation Hardi case, a constitution bench of this court held that the question whether a particular provision is mandatory or directory cannot be resolved by laying down any general rule, and it would depend upon the facts of each case, and for that purpose the object of the statutes in making out the provision is the determining factor. Para. In Saddam Sir, election tribunal is considering the provisions of the code dealing with the trial of the suits. It was opined that now a code procedure must be regarded as such. It is procedure, something designed to facilitate justice. To technical construction of sections that leaves no room for reasonable elasticity of interruption should therefore be guarded against. Para. In the facts and circumstances of the case, the maximum of equity that an act of court shall prejudice no man shall be applicable. This maxi is founded upon justice and good sense, which serves a safe and certain guide for the administration of law. Para. The High Court's orders are clearly indemnify and are set aside. The appeals are followed but without any order as to costs. चलिए इसको ट्रांसक्राइब कर लीजिए, मिलाएंगे.